Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. When we have custody battles involving either divorced parents or parents who were never married, but they're nonetheless involved in a dispute about custody, it takes many, many months for the court to come to a final determination. The court has many, many factors that the statute requires that it take into account. Oftentimes, the court has to have testimony from the parties, sometimes from the child himself, sometimes from experts, sometimes from psychologists, sometimes from people from school, all sorts of things that the court takes into account when it makes that final determination. And that is why the court takes many, many months to do it. The court will often feel that in order to go through it thoroughly, and since it involves the future of a child, the court doesn't do this willy-nilly. So the court is not likely to make a fast, non-deliberate decision regarding custody. However, the court is also mindful of the fact that you got to do something with the kid in the middle of the dispute, because dad wants custody, mom wants custody, all of a sudden nobody has custody. So what happens in the interim? Well, the court is amenable to making temporary orders of custody, or what we call interim orders, until such time as it has an opportunity to make a final ruling. Now, how does one go about getting that? Well, typically what will happen is this. One party will file demanding custody. The papers will say to the court, I've had custody, child's been living with me all this time, mom lives out of state, or mom is never around, therefore I want ultimate custody. In the interim, please grant me temporary custody. Now the court will typically either do that on an ex parte basis, meaning without any argument, on a temporary basis if the court feels a compelling reason to do so, or the court will hold a temporary hearing just for the purposes of making a temporary placement, a temporary custody. Now, at that temporary hearing, the parties will get a chance to argue about what's fair and what's not, what the court should or should not take into account when determining the temporary custody. But the court does accept the notion that having some level of placement before the final order is made is appropriate. I mean, the child has to feel some sense of stability. So we can't have the child living out of a duffel bag. That is not considered necessarily desirable. Generally speaking, it makes more sense for the child to have a place to stay. You got to watch out, though, because the court sometimes will look at the inertia that's created by the temporary placement and have it sort of bleed into the final placement. In other words, the court might say, well, child's already well adjusted to this area. I know it's supposed to be temporary placement, but I feel that it's in the best interest of the child to continue the temporary placement as a final placement. And you got to watch out for that, because sometimes it's actually true and sometimes it's just laziness, where the court says, okay, well, it's just temporary, and they tell you that, knowing full well that that's probably how it's going to work out at the end, and that's not fair to you. So therefore, you got to be very, very careful to argue the temporary placement, to vigorously defend against it if you feel it's inappropriate. And if there are problems along the way, don't say to yourself, well, you know what, it's only temporary, the court's going to make a final decision. Because if you don't bring it to the court's attention along the way what the problems are, the court might well think that the temporary placement is a good final idea too, and you don't want that. If you have any questions about your case and how it's developing, reach out and we'll be glad to help you out.